Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing spouses who are waiting abroad with their K-3, CR-1, or IR-1 spouse. They're basically waiting for the visa to process. And the reason I'm making this video is I often see these folks, they kind of conflate themselves with their spouse. And I totally understand this. You know, marriage, you are a single unit. You know, you're married to each other. In many ways, it's an institution and you're bound together. I totally get that. I understand the thinking, and I certainly sympathize for folks who are waiting with their spouse. However, that doesn't matter. It doesn't matter with respect to how fast the case is going to go. And I see people conflate themselves with the applicant. And I'll often hear folks that are in this situation, they'll tell me, well, I can't go back to the United States until he or she gets their visa. Well, that is not technically speaking true. An American citizen can always go back to the United States. And the position of the government is you can always go back to the United States. Your spouse, a non-resident alien of the United States who's being adjudicated for immigrant status, that person doesn't have the right to do that. They're in a qualitatively different position. And I'm not making this video to be dismissive or to be sort of short with people. The reason for the video is to provide insight so you understand that you're not in the same position. And I totally get it. People want this to move faster. This sort of discussion often comes up in the context of people who are wanting to go ahead and request like expedited processing. And they sort of say, well, you know, I'm waiting over here, I can't get back to work, or whatever they'll say. To the government, that's not how they view it. You know, especially, and every case is different. There may be facts that may allow for expedited processing, but as a practical matter, no. If it's a routine case, you know, everybody's waiting in line and they're dealing with it as fast as they can. Now, some cases it gets to the point where it goes beyond reasonableness, but in the vast majority of cases, you know, people I see, they get very frustrated. And I think there's also an element where it's like, I'm an American, why can't we get through this? Well, you are. The counterparty is not. The beneficiary is not an American. They don't have these same rights. So again, this isn't being made to sort of, I don't know, be vindictive or something toward, you know, the spouses that are waiting through this. It's more being made to just provide insight as to why the system does not really view, it does not view an American the same way as their spouse who's a non-resident alien.